This is where we grew up. In raging storms and freezing temperatures. The west coast of Norway demands something special from who you are and what you wear. In these conditions, you need to trust your clothing. Function followed by form. We're beyond fashion. We are what legends and fishermen have been wearing since 1853.
Before what we do. We are a charitable trust set up in Wanaka, based in the Southern Lakes. Our mission is to inspire, educate, and enable communities to go towards a regenerative, thriving community. The way that we do this is very holistic, and we really base ourselves on a model around the Sustainable Development Goals, looking at everything from mental health and well-being, no poverty, no hunger, right through to climate action, which is really going to be the focus of this afternoon's talk. So we've got with us today two pretty exceptional women who are really leading the conversation in law around what we're doing to get climate action not just going but accelerated. And I'm really excited about the actions coming out of Lawyers for Climate Action. So our first speaker is Jenny Cooper, and Jenny is a leading commercial barrister, and she is the founding president, co-founder and inaugural president, is that right, Jenny, of Lawyers for Climate Action. There's a group of about 300 lawyers, is that right at the moment, or is it growing every day? Oh.
Sorry, I'm back.
Okay. It's like, oh no,
it's a bad start.
So I think there's about 300 lawyers in the Lawyers for Climate Action as members, is that right? And it's really driving towards getting those net emissions to below 1.5, so the Paris Agreement goal. And Deborah Doington, who's a property lawyer, she's also working with Kaingaora and getting through education for sustainability for lawyers. And she is coming to us from your kitchen in Hobsonville, is that right?
Yes, that's right.
So I will just sort of set out some of the things for the Zoom call. Everybody can chat, so please jump on the chats just so that when the presentations go through, if you've got any questions, jump on the chats. Both Jenny and Deborah can see your chats coming through, and we'll try to answer as soon as possible. We've also got Fred and we've got Olivia, who are going to be here, so please get in touch with them at Wao Aotearoa if you've got any questions for the host for us to pass on afterwards. We are going to be recording the session because we'd love to be able to have this available to anyone who is not able to join us here right now. The idea is that this would be available to them to watch afterwards when they're ready. And with that, I am going to hand over to Jenny and to Deborah, and to say a huge thank you from us down here for giving your time up and organising this workshop for us.
Thank you very much.
I think that Jenny has frozen again.
Yeah.
Deborah, you may have to just take over.
Just give her a mo, see if she comes back.
This has been working beautifully for the past half hour, and now we will just, okay. It might just be a problem with Jenny's connection.
So here we go.
She's back again.
Yeah. Can you hear us, Jenny?
Okay.
You can unmute, Jenny.
You need to unmute yourself. Oh, it says you're the host.
Right. Am I, can you hear me? I'm not mute. All right. I apologize.
Can't see your screen though.
Can't see my screen. Ah, okay. Sorry. I'll try share screen again. Okay, how's that?
That's good.
All right. I really apologize for that. This has thrown me significantly. I now need to work out how to get to the start of my oh dear, hang on. Sorry, I'm just going to stop the share and start this show again. Okay, can you see the slides?
Not yet.
No, okay.
You need to share.
Okay.
Yep, and we're at the beginning.
Great. All right. Okay. Well, hello everybody. I'm sorry about that. We're very sorry that we can't be in Wanaka with you because things are very much simpler. Anyway, we'll do our best. So look, as Monique was saying, I am the president of Lawyers for Climate Action NZ. And I'm here with Deborah, who's another member of Lawyers for Climate Action NZ, and we're both obviously practicing lawyers, and we're here to talk you through various aspects of climate risk and liability from a bit of a legal perspective. So I wanted to start, first of all, by talking a little bit about Lawyers for Climate Action and who we are. And then we're going to talk about some of the legal issues for businesses in particular, arising in relation to climate change. And then we'll talk a little bit about some of the legal issues for local government and public bodies. And then we're going to finish up with talking more generally about what are the legal tools that are available for community groups, NGOs, and individuals who are keen to take action on climate change. We are interested in your questions, whether you want to feed them through in the chat as we go through or at the end. I'm not sure how good we'll be at responding to them quickly in the chat, but we'll certainly make sure that we leave time at the end and we'll try and get back to them if we don't manage to pick them up as we go through. So I'm going to kick off and then I'll hand over to Deborah to talk particularly about some of the issues for business, and then we'll come back to me to talk about local government. I suppose one other preliminary thing to say is, although we are obviously members of Lawyers for Climate Action NZ, but this presentation is our own views, and obviously it's not intended to be legal advice, but hopefully of interest and a good taster for you. So first of all, just to say a little about Lawyers for Climate Action NZ. So we got started about 2 years ago. So we're relatively new. We've grown quite quickly to around 350 lawyer members. So to be a full member, we require our members to have law degrees because our point of difference is that we are a group of lawyers. But we also have associate members, and anyone is welcome to be an associate member. And our focus is, first of all, we wanted to really raise awareness about the threat of climate change and also the implications of climate change adaptation for a wider group of people who have not perhaps traditionally or until now been so engaged in environmental issues, and that includes a lot of lawyers. And then secondly, we were keen to advocate for legislation and policies to actually address the climate emergency. And as lawyers, we are obviously quite focused on making sure that the legislation and policies we do have really work. You know, they're fit for purpose, that they are actually enforced and policed, And it's also really important to us that they align with principles of the rule of law, Te Tiriti o Waitangi, international obligations, and with the New Zealand Bill of Rights Act, and obviously international human rights treaties. And then the sort of third aspect of our work is that we have a pro bono clearinghouse type program where we try to act as a contact point between community groups who are working to address climate change and individual lawyers who are willing to offer some pro bono assistance to help them. And Deborah actually is in charge of coordinating that. So that's what we do. And if you're interested in joining us or finding out more, I've put our website address there at the bottom of the slide. So moving on, I guess, to talk a little bit about climate risk. And I'm assuming that everybody who has taken the time to join this session is pretty well aware of the basics of climate change. So I won't spend time on that. But just to draw your attention to a good source of a little bit more information about how climate change is affecting and will likely continue to affect New Zealand specifically. And that's the first National Climate Change Risk Assessment, which was published by the Ministry for the Environment last year. And that's quite a useful document. It sets out, it's not too long, but it's reasonably comprehensive, and it sets out the different types of risks to New Zealand. And they're the kinds of things that you would expect. There's obviously risks to natural ecosystems arising from changes in weather patterns and so on. There's risks of displacement of people. Now, that bears a little bit of reflection on. We have a lot of people living in very exposed coastal communities in New Zealand. A lot of our cities are very close to the water and very low lying. And as sea levels rise and we have increasing issues with storms, that is going to require some communities to relocate, which is going to be quite a big issue. Then obviously extreme weather events. I mean, everybody's sort of familiar with that. But then the other, perhaps less intuitive risk that the report identifies is the risk of maladaptation and the risk that our institutions won't be fit for the task of adaptation. So I think those two are particularly pertinent to the conversation today because it really highlights the importance of looking ahead and being well informed about what is likely to change in the future and what our needs will be in the future, and to try and make sure that the decisions we make today won't create bigger problems than we have already. So I think that's a useful insight from that particular report. So bringing it round to business and what are the particular risks. So they really fall into two categories. And the first and obvious one is the physical risks. So that's obviously the damage caused by extreme weather events or by change in weather patterns or rising sea levels. But the slightly more complex, I suppose, area is the transition risks. And I think that's perhaps the part of the equation that some businesses haven't yet got their heads around. And those are things like changes in government policy. So for example, we might suddenly find the government no longer accepting sort of certain forms of electricity generation being used by businesses that contract to the government, for example, or suddenly imposing new carbon tariffs or import restrictions on certain goods which are high carbon, so that kind of thing. So various policy issues that might come up, or another example might be high tariffs for international travel. And then legal risks, which are a whole category in themselves, and I'll come back and talk about those in a moment. Technology risks, so obviously there's the risk that existing technology becomes obsolete or unusable, or that new technology comes in and completely disrupts an entire area of business or an entire market. Market risks, so again, there's a risk that entire markets might simply disappear, whether through changing consumer habits and ideas or through regulation. So for example, It probably seemed completely far-fetched not that long ago to think that there might be restrictions on how much meat a country is willing to import. And I think we're still away from that, but you know, increasingly the conversation is moving in new directions. So you just don't know what may or may not happen at a certain point. And reputation risks. And I think we're seeing very strongly increasing consumer interest and concern about environmental issues and the potential for those to very quickly change the fortunes of businesses. Now, that new risk environment and all those new potential risk areas and uncertainties flow through into governance issues for businesses. And so there's been quite a focus in the last 12 or 18 months on directors' duties. So we saw in Australia a couple of years ago, this got picked up by Institute of Directors in Australia, who got a legal opinion from Noel Hutton SC on the responsibility of directors to take into account climate risks. And that was then picked up in New Zealand by the Aotearoa Circle group of companies who commissioned Chapman Tripp and Alan Galbraith QC to do a similar opinion here. And really the guts of that is that climate risk needs to be treated by directors in the same way as any other material financial risk. So essentially directors need to be exercising the same care, diligence and skill they would exercise in relation to other types of risks in relation to climate risk. So all that those opinions, legal opinions, were really saying is climate change is not a special category of risk. It's just like any other risk. You need to be aware of it, you need to assess it, you need to act prudently to manage it. Now, the other aspect of directors' duties is, of course, the overriding duty of a company director is to act in the best interests of the company. And what that exactly means is sort of a little bit of an uncertain issue. There's different interpretations have been taken at different times. But there is, I think, a reasonably strong consensus that what it doesn't mean is that a director should simply ignore everything other than the financial interests of shareholders. So I think this is reasonably clear that a director can meet their duty to act in the best interests of the company while also taking into account interests of the environment and the interests of stakeholders, such as consumers, employees, and the general public. And to the extent that there's any doubt about this, a private members bill has been introduced by the MP Duncan Webb to clarify that. So if that bill is passed, that will expressly clarify that directors are permitted to take into account environmental interests when they are considering the best interests of the company. So it'd be interesting to see if that goes through. But as I say, I think that is really a clarification of the status quo rather than a radical development of the law. The other aspect of governance, which is super topical, is climate-related financial disclosure. So the law, a new law to require certain companies to make climate-related financial disclosure was in fact passed just a couple of days ago. And that will apply rules to the major listed companies, banks and insurers, among others, to disclose their climate-related financial risks. The exact details of that disclosure are yet to be worked out. So XRB has been tasked with producing a regulation, but it will be along the lines of the TCFD task force recommendations, which were very comprehensive. So that they came out a couple of years ago and have been adopted voluntarily by some major international organizations. And as I say, will from probably next year become compulsory for those banks and insurers and other major corporates. And now there is some of you may think, well, okay, that's fine if you're Westpac or BNZ, but it's not going to affect my business or my client's business. But in fact, it will have quite a powerful flow-on effect, because banks and insurers will have to understand the risks across their balance sheets. So they will need to understand the climate risk profiles of their customers and what's out there sitting on their books. So to give an example, if you are a bank and you've got a large domestic loan portfolio, a large portfolio of household mortgages, then one aspect of your climate risk will be how many of those mortgages are lent on properties which are vulnerable to sea level rise and flooding. And you may also be thinking about how much of that risk is likely to become uninsured if the insurance companies withdraw cover from some of those properties before the term of the mortgage has expired. Equally, the banks will be looking very closely at their business lending portfolios and how much climate risk they're carrying. And some of you may have seen in the news, I think it was just yesterday, the loan sustainable, I've forgotten the exact way to describe it, but the sustainability linked loan package that Westpac and PAMU have entered into, where a very large amount of lending to PAMU and its portfolio of farms is going to be expressly tied to sustainability goals, including carbon emissions reductions. So that presumably is also reflecting a desire by Westpac not only to encourage its clients in the right direction, but also a wish to de-risk their lending portfolio. So as I say, there's likely going to be a flow-on effect in terms of the availability and cost of finance and insurance for some companies as a result of climate-related financial disclosure. So coming back to liability and litigation risk then, this takes really a variety of forms. So there's a risk of contract claims arising from disruption. So inevitably, we're going to go through periods of rapid change and disruption, and those are going to have flow-on effects, and there's going to be issues about who bears the risk. And I think Deborah will talk a little bit more about that. Another category is shareholder and creditor claims. So that might come down to things like failing to adequately disclose risk when entering into transactions or issuing shares, or in relation to insurance, potentially breach of directors' duties of care for failing to adequately disclose, mitigate and manage climate-related risks. The next bullet point I've got there is consumer claims, and I think that's going to be another area where businesses are going to come under increasing pressure as accusations of greenwashing get made. So at the moment, obviously, a lot of businesses are very highly motivated to present their services and goods as being very environmentally friendly, but how well do those claims really stack up? And of course, the Commerce Commission will be looking closely at that in relation to the laws on unsubstantiated claims. And as a little example, perhaps, you may have seen the recent First Gas advertising campaign, which focused on gas going zero carbon, or I think the term was gas is changing. And I have to be careful not to misquote them. So I can't remember the exact terms that were used in the ad, but the overall impression was that so fossil fuel gas is going to be transitioned to a renewable form. And Lawyers for Climate Action actually made a complaint about the ad to the Advertising Standards Board on the basis that we considered it was misleading, because it gave the impression that these changes, which were in fact still at a very early stage of investigation, were imminent. And that is in fact not the case. And that complaint was upheld by the Advertising Standards Authority, and the advertising was withdrawn or amended. And then the next category of potential liability is tort claims, potentially for environmental damage. I've mentioned the Smith and Fonterra case there, which you may have heard about. So Mike Smith brought proceedings against New Zealand's 7 largest emitters of greenhouse gases, alleging, seeking essentially orders requiring them to cut their emissions. And those were based on various tort type claims. So nuisance, negligence, and a sort of novel duty of care. At the moment, there was a court of appeal. The two of the negligence and nuisance claims were struck out by the High Court, but not the novel duty. There was an appeal to the Court of Appeal, and the Court of Appeal just issued its judgment a few days ago, which essentially struck out all 3 claims. So we'll have to wait and see where that goes to see whether it goes up to the Supreme Court, and if so, whether they take a different view. So at the moment, the potential for tort claims doesn't look large, but it's very, very fact specific. So I wouldn't entirely rule it out. And then of course, various potential forms of regulatory liability arising out of new regulations being introduced, such as the emissions trading scheme and so on. So with that, I'll pass over to Deborah.
Thanks, Jenny. So what I would like to do is have a look at climate risk and the day-to-day operations of a business, any business. Identifying those risks might take some effort. The risks might not be immediately apparent, and you might need others to help out in identifying them and determining them. But one of the things that can be really useful in making sure that the risks are addressed is actually to put climate change onto the agenda, or put climate risk onto the agenda, so that it doesn't become an issue that is debated or discussed after the business decisions are made, but it actually becomes an integral part of how businesses decide what course of action they're going to take. So in much the same way, I suppose, as health and safety in employment has become very much an issue on everybody's agenda, it's a similar sort of way that climate risk perhaps ought to be addressed. You'll be used to, I think, either creating, if you're in the legal field, or using, if you're not, compliance procedures to make sure that regulatory obligations are met. So consider these in the light of climate change. Consider how climate risk might fit within those existing procedures, or perhaps whether there needs to be an overarching analysis of what sort of risk there might be in relation to regulatory obligations generally, and incorporate those climate issues into those procedures. Have a look too at contracts, existing and future contracts, and start to look at them through a climate lens. Start to think about the risks that might be associated with the activity that the contract governs, and how those risks are allocated, what responsibilities there might be, what opportunities for change might there be. One area that I think is really worthwhile considering is the force majeure clause, or the clause that deals with events of delay that might be considered to be out of control. So boilerplate clauses that are at the back of your contract and perhaps aren't generally negotiated, but perhaps also might have been more in the recent light of COVID. Think though about the impact of delay, of inaccessibility to sites, loss of insurance, delays in supply that might be a result of floods, droughts, fires, storms, the types of things that are associated with climate change. Consider where the responsibility might be for this. Is it appropriate that one party is responsible, or actually is this something that's happening to us all? Consider whether there ought to be a way of kind of working through these this problem, given that it's likely to be with us for these sorts of disruptions are likely to be with us for quite some time. Think too about your insurance. Talk to your insurance broker about risks to existing insurance cover, risks that might be coming in the future to insurance cover. And Jenny's already mentioned one that's very relevant. What about the expected insurance retreat over property that is subject to the likes of flooding and stormwater surges? How will that impact on you and your business? There's a lot of information available and written about this expected insurance retreat. It's information that is available on the web. It's not information that's hidden and unknown. But have a chat to your insurers about where that might impact your business or what other insurance might be there. And of course, just to reiterate this need to make sure that any claims that are being made in marketing or otherwise are not misleading, do not amount to greenwashing. Can you move on to the next slide, please, Jenny?
I'll try.
Okay.
You, so there we go.
Yeah, you've done it. Cool. Okay. Good. So I do want to have a little bit of a chat about how lawyers can be used in this. And because I know there are some lawyers in the audience, but there are also people who are not lawyers. The first thing that I really want to understand or to recognize in relation to this is that it is an evolving area. Dealing with there are evolving issues relating to climate generally, but there are evolving issues relating to the legal scenario that lawyers will be providing their advice. And lawyers who are trusted advisors like to rely on research. We like to precisely understand facts and assumptions before giving legal opinions. And they might draw from years of experience in doing this. So it looks perhaps like a gut response, but actually they're relying on a deep understanding of the law. We like to know our stuff before giving opinions. But actually, when it comes to climate risk and climate change, there might just need to be a bit of a mind shift about this and something of a change, a willingness perhaps to ask questions rather than always have the solutions. And sometimes even when asking those questions when you don't even really know what the relevance is of the question, keep on asking questions about what climate risk might exist, how might obligations to reduce carbon emissions impact on this project, this legal situation, this relationship that we might have. And so to those of you who are not lawyers, I think do get to know and understand what is happening in your industry in relation to climate. There is so much going on at the moment. There is so much being produced in the way of new policy, new regulation for sure, new advice, sharing of information. So really do get to the bottom of what is going on in your industry. And if your lawyer doesn't know about this, then start to tell them about it and ask them questions about it. And through the course of that, then consider those the risks that might need to be assessed, but also look out for opportunities that there might be for climate action that might go just a bit beyond dealing with the risk, but dealing more with the bigger risk of the risk to our Earth as a result of climate. Okay, let's try for the next slide. So in this slide, I have put up some legal considerations that I think might be relevant when dealing with climate. And this is across the board of all sorts of different legal issues. If you're a property lawyer like me, or you're involved in other aspects of business law, even, I don't know, might come up in family law too, but generally these types of things will be relevant and will be tailored towards your particular area of legal issues. The first is the validity of assumptions. So as we conduct as ourselves in business, as we carry on business, we learn from what happened last year. We learn from the last project that we had. And to make life easier for ourselves, we make assumptions that things can be done in the way that it has been done in the past. And this just helps things roll more easily. And sometimes some of these assumptions become so basic to what we're doing that we don't turn our mind to them again. Now is the time to be thinking about all of underlying assumptions and whether they remain valid in the light of climate risk and the expecting changes, whether those are regulatory changes or whether those are social changes, and about what is acceptable. Turn your mind to each of those. And similarly, don't consider that existing approvals, permits or consents that have been granted in an environment where carbon emissions are not taken into account might still be able to be easily applied or used, whether that's because of changes in the law relating to those approvals, or whether it's changes in associated laws, or whether that's what is socially acceptable. We've talked already about, briefly about impact on insurability and impact on use, particularly in relation to property, but these things will apply not just to property. Any restrictions that there are on use of assets or insurability of those assets are clearly going to impact on asset value. So that's something too to be considering and bearing in mind. Operational costs too, as new regulatory requirements will come into play, requiring new skills, new technology to be taken into account. Operational costs are going to impact on costs of projects and costs of the business going forward. Timeframes in the context of contractual obligations we've already talked about, and the security of supply is something that we live with the issues right now. So we're kind of used to dealing with that with COVID, but it will continue to be an issue as droughts, floods, storms, etc. impact supply. Procurement expectations is something that ought to be newly taken into account. Again, Jenny's mentioned this briefly, but where organisations are requiring that our organisation must comply with certain or aim to achieve certain climate expectations before doing business with their organisation, this is going to impact on the supply of work going forward. And we've heard about the requirements to fit the expectation of the larger organisations' requirements to report on risk, how they will filter down. But also the government has new expectations too that will need to be met in relation to procurement. Their new procurement rules are imposing obligations on organisations to deal not just with climate change actually, but specifically to be taking steps to address this in their own business. Funding requirements. You've heard about KPIs that might relate to sustainable actions being taken. And I listened to a presentation just the other day, actually, where somebody who deals in this area was saying that as more and more of this is happening, sustainable expectations will become more and more the norm, so that there won't actually be a distinction between sustainable finance and finance generally. A number of different organisations are providing finance at different sorts of rates or at improved terms where sustainability issues or climate change issues can be taken into account. And this is not just at the big end of town. I think it's ANZ who has a product where if certain Homestar expectations are met, the funding costs are different. Legal obligations of decision makers, heard about directors. I'm going to talk a little bit in a minute too about those decision makers who are trustees and the obligations that might be placed on them. So let's have a look at the next slide. I've put up some circumstances that I think of about where these legal issues might be relevant. And of course, as a property lawyer, I'm kind of swayed by how I draw my examples from the property world, but it's not just in the property world. Any due diligence inquiry that might be made in relation to an acquisition will now require, if it's to be properly made, will anticipate considering climate risk and climate issues that are coming up there. So not just in relation to the ongoing operation of the business, but also to the use and asset value of any of the assets that are being transferred. At the other end of the due diligence inquiry, though, do think about any representations that might be made on a sale, particularly, again, in the property side of things. I think this is an issue if sales are being made via agents. If the sale is of a property that with a very easy investigation, you can see has the prospect of being flooded as a result of sea level rise or storm surges, then I'm sure that this is a defect for the purposes of the regulatory requirements on real estate agents, and as a result must be made known to potential purchasers. Forward planning is, of course, a circumstance where knowing and understanding what's coming on might be relevant. And in that context, I want to talk a little bit about MBIE's plan for its Building for Climate Change program, just as an example. For a couple of years now, MBIE has been consulting at large about its Building for Climate Change program, and it's not quite known when this is going to, from a regulatory point of view, kick into gear, although people are starting to take it into account. But one thing that is certain is that it is coming. MBIE says that by the end of the year, we might have some might know some program about when this will be brought into being. But it definitely is coming, whatever the timing of it is. So I want to tell you really briefly about it. There are two parts to this program. They're both about reducing carbon emissions that come from buildings, and at the moment they're concentrating on new buildings. So one part of it is about the operation of a building as it exists, and it anticipates the identification of the carbon emissions that result from the use of that building, from the use of the from the generation of the energy, the use of electricity, the use of water, and it anticipates that these will be made known publicly, assessed on a per square metre basis and made known publicly, and that this information will be available throughout the operation of the building. Initially, it's about identification, then it's going to be about meeting targets, and those targets are going to reduce over time so that we get fewer and fewer carbon emissions from the operation of buildings. But the other side of this climate change program relates to the whole of the life of a building. So from the moment that the tree is chopped down to make the timber through to the date when the building is demolished and parts of it go for recycling, other parts of it might go off to waste, to be disposed of as waste. And the intention is that during that entire life of that building, the carbon emissions will be measured, the carbon emissions will be publicly made known, the carbon emissions will achieve certain targets, and that those targets will get lower and lower and lower, so we get fewer and fewer emissions over time. And this is going to be tied in with the building consent process, so that CCCs will not be issued until there's been compliance with these carbon emissions criteria. So if you or your clients have a business that operates anywhere within that cycle, then this is law that is relevant for you. So if you have a trucking business and you drive the logs from the forest to the sawmill, then you're going to need to identify the carbon emissions that relate to that, that activity, and you make them known and ultimately reduce them. So this program of itself needs it's going to require new skills and new technology over time, and is a really good example of the need to think ahead about operational costs of the business and forward planning for what might need to be done. Contracts, we talked a bit about force majeure, I won't talk about that again. But the second point is dispute resolution. If climate action or climate risk or climate change in general is part of your contractual obligation, make sure that you address whether that needs to be taken into account and how disputes are resolved. We'll often identify that we usually identify a process for dealing with a dispute, and that might involve an expert in making some final judgments. Make sure that if environmental issues are to be part of that decision making, then they are identified in that process, and that the expert is somebody who has those appropriate skills. Let's go to the next one. So this is really a slide to quickly identify that there are steps that businesses can take, not just to address risk, but actually to go beyond that, to take climate action, to take steps to improve things and make change easier. And again, advice might be needed from others. And again, putting climate change onto the agenda is going to be helpful in this. So not just looking at what the regulatory obligations might be, but actually looking at what further steps might be taken to take climate action. One of the first and most obvious, and one that a lot of people are doing, is actually to measure your own emissions, to identify those and to reduce them, something that's certainly worthwhile considering and undertaking. And there are plenty of people that can help, plenty of organisations that can help in doing that. And actually, it's not necessarily as hard as it might seem. Consider whether you might want to use your own contractual terms to leverage influence on others. If there are circumstances where you in your business might want to know that the people you're doing business with are taking certain climate action, then your contracts with them is a real opportunity to do something about that. And at the same time, keep on asking questions, even if you don't want it in their contract. Ask questions of your suppliers, of the people with whom you do business, about what they're doing and to what extent they're taking into account climate action in their business decisions. And the final point that I've got there is about telling your story. And it doesn't have to be a story of perfection. In fact, it's best that it's not, because you're probably not doing things perfectly. Everybody knows this is tough stuff, and trying to understand what's needed is not necessarily easy. But letting people know where you're going on that climate story. Next slide, please, Jenny. I want to tell you about the Chancery Lane project. And for those of you who are lawyers, this is an abundant resource, something that's really worthwhile looking at. If you look up Chancery Lane on Google, you'll find them really easily. And for those of you who are not lawyers, it's worthwhile telling your lawyers about this resource. The Chancery Lane project is a group of lawyers around the world. I think there are about 1,600 or so when last I looked, who are contributing to drafting for climate change. They draft clauses that are suitable for use in contracts to deal with a range of different climate issues and across a range of different things, you know, from company constitutions to due diligence clauses, or all sorts of things where climate might be an issue. They're drafted to fit in with the British law, so they're not immediately able to be used to just pick up and dump into a New Zealand document, but nonetheless they're very, very useful because they identify the issues, they provide useful definitions, they kind of guide drafters in a way to think about the things that might be included in there. And they're very active here in New Zealand and nearby in Asia and Pacific and in Australia too. So the Chancery Lane project, worthwhile having a look at. The last slide that I'd like to talk about, thanks, is I just want to take a minute to consider trusts and wills. And whilst these are not necessarily immediately aligned with the day-to-day business activity, many people who are in business have trusts established as part of the makeup of their organisation. And most of us should have a will. So I just want to speak briefly about that. Jenny mentioned earlier on an opinion that had been prepared for Aotearoa Circle about the legal obligations on directors. And earlier this year, Chapman Tripp was also responsible for creating a legal opinion looking at the legal duties of trustees. This is an opinion that is available. You can get it from the Chapman Tripp website by making a request, but it's also available on the Aotearoa Circle website. It's a good read, an impactful read. I want to tell you about a couple of things that they identify. And the first question that they address is, to what extent are trustees expected to investigate and know about the impact of climate risk on investments? And similarly to directors, their responsibility is the same sort of thing as might apply for other risks. It's clear that trustees are expected to take it to know the impact of climate risk on investments that they are making and to take them into account in their decision making. Another point that is discussed briefly in the opinion is the obligation of trustees to be impartial, to have impartiality between the different beneficiaries. And I just want to talk about that for a minute, because it's very common in New Zealand in our trusts to have multiple generations of beneficiaries. For a trust to be established whereby the people who are setting up the trust are probably the first lot of beneficiaries, but so will their children be, and their grandchildren and others down the way. Any remoter issue is the language that's commonly used. There's a requirement under our trust legislation to have impartiality between beneficiaries. And whilst that may be changed within the context of the trust deed, it's something that really takes on an interesting viewpoint when you throw climate risk and climate change into the issues that might be accounted for in considering that impartiality. Another thing that's made clear in the opinion is that any decisions that are made by trustees must be for the benefit of these of the beneficiaries. So this is not, in the absence of a mandate to do so, an opportunity to take into account the benefit to the world at large of the decisions and the need to make climate change issues, but must be for the beneficiaries. So anybody wanting to have greater input into those sort of moral type decisions will need a specific mandate from the trust documentation to be able to do that. So those of you who are trustees or who are considering being trustees or are asked to being trustees, I wonder for you whether this isn't an opportunity to take some climate action. On what terms might you be a trustee? Do you want it to be clear from the documentation that you can account for climate issues above and beyond taking into account climate risk on investments in your role as a trustee, while bearing in mind these other obligations to the beneficiaries? In the last couple of seconds, a couple of points about climate action from the grave. We're making your will. It's a funny time to think about climate action, hey, but I recently have updated my will, and it made me think about this. Think about what sorts of things you can provide in your will that you weren't willing to deal with during the course of your lifetime that might be dealt with in dealing with the climate. How, for example, will your will deal with any fossil fuels vehicles that you own at the time of your death? And is it an opportunity to deal with carbon debt? In our wills, we deal with we place obligations on our trustees to repay any financial debts that we may have. But is this an opportunity also for them to be obliged to take an account of what sort of emissions you might have made during your lifetime and to purchase carbon credits in relation to that? So on that, I'm going to hand back to you, Jenny, to look at local government.
Thank you very much, Deborah. That's really interesting thoughts there. And apologies for somewhat wonky slides. I had to stop and restart, but I think we got there. Cool. So just a reminder to those of you listening, do send us some questions on the chat. So we are intending to have some time at the end to deal with those. So please do feel free to send them through. All right, so local government. So really, some of the risks faced by local government and public bodies are the same risks we've already talked about for businesses. So there's obviously physical risks to infrastructure and assets, and there's the same sort of also policy and regulatory legal type risks. But obviously local government and public bodies do have additional statutory obligations which they need to think about in addition to the types of things that private businesses need to think about. And in particular, the critical thing, of course, the critical difference is that decisions by public decision makers are subject to judicial review by the court. So often, not always, but often, they're decisions which are made within a statutory framework, and so they need to be consistent with the obligations that that statutory framework imposes. And so there's just an added layer of accountability that those public decision makers need to meet, which creates an additional layer of legal risk, because of course there's a risk that someone who is not satisfied with that decision may seek to challenge it before the court. And I think local government and public bodies also have a heightened risk of liability for damages. Now, although I talked earlier about the fact that at the moment, tort-based claims have had a bit of a setback from the Court of Appeal in the Smith and Fonterra case. That case is all about private companies. We haven't seen a case yet that I can think of anyway, where an individual or group of individuals has tried to hold a local body accountable in damages for climate-related loss. And so there is certainly at least a potential for that kind of claim to be made, and it's not yet clear whether that would be successful, but I would say difficult to rule out. And I've put a reference there and a link in the slide to a paper that Jack Hodder QC gave a couple of years ago for local government NZ on the risk of claims against councils to climate change related loss. And his argument was along the lines that if you look at the history of sort of large damages claims in New Zealand, obviously the leaky building litigation really stands out. And a lot of that has been against councils because in a way, they often become the defendant of last resort as the sort of private players face insolvency or otherwise drop out of the picture. Then people who have suffered loss, who are looking for a way to compensate that, will tend to turn to councils. And so I think when we think about things like consenting of developments in flood-prone areas, that's the kind of area where I think councils potentially need to be thinking quite hard about their potential liability in that sort of area. So as I mentioned, a lot of local body decision making occurs in a statutory framework. So the obvious act there is, of course, the Local Government Act. So pretty much everything that councils do needs to be in accordance with that act. And there's a number of relevant provisions, but I've just mentioned the ones there which I think potentially form the basis for a wider duty to take account of climate change and related issues. So first of all, in the purpose statement of the Act in section 10, one of the purposes of local government is to promote the social, economic, environmental and cultural well-being of communities in the present and for the future. And now when we're talking about climate change, obviously, we're already experiencing some of the effects now, but the real consequences of what we're doing now are going to be felt in the future and for a very long time in the future. And so that responsibility to take account of well-being in the future immediately increases, I would argue, the burden on councils to attribute greater weight to those potential risks than might otherwise be the case with no such duty. Then I've also referred to the section 14C duty to take account of the need to maintain and enhance quality of the environment, the obligation to prudently manage assets and liabilities. Now, arguably that also imports an obligation to think about, well, what are the risks to those assets? And it wouldn't be prudent to ignore the potential effects of climate change on them. So example would be increased risks of flooding, and not only from sea level rise, but from changes in weather patterns and increased rainfall, increased humidity, and so on and so forth, change in temperatures. And when we come to council-controlled organisations, and I apologise, I'm not really familiar with what council-controlled organisations Queenstown Lakes may have, but they're obviously a big feature of the local government landscape up here in Auckland. Council-controlled organisations are required to act in accordance with council objectives, and councils are generally ultimately accountable for actions taken by the CCOs. So that is something that also needs to be factored into the governance of those organisations. And then, of course, there's various other types of legislation which local bodies are required to comply with when they're performing particular roles. So there's obviously the Resource Management Act, which requires regard to the effects of climate change, and until now has actually prevented councils from taking into account the effect of emissions of an activity on climate change, but the particular sections that prevented that have now been repealed, and I think that repeal comes into effect maybe from the end of this year or next year. I'm not quite sure of this precise date, but in any case, that position has now been changed, and that will flow through into practice very shortly. Another area that councils, of course, need to be very mindful of climate change in is in relation to transport. Now, the Land Transport Management Act is, of course, the act that governs regional land transport policies and sets out the requirements that those are required to meet. One of which is that a regional land transport plan has to be consistent with the government's policy statement, or GPS, on transport. And for those of you who are involved in the transport area, you'll know that the government policy statement on transport talks about decarbonisation of transport to achieve climate change objectives. It doesn't say precisely when or how that must happen, but it certainly sets a very clear statement of intent that the trajectory of transport must be towards decarbonisation. And so that should be reflected in the regional land transport plans that various local authorities adopt. And some of you may be aware that All Aboard Aotearoa Incorporated, which is an umbrella organisation of various climate groups, including Lawyers for Climate Action, has brought judicial review proceedings against Auckland Transport and Auckland Council on the grounds that we say that the Auckland Regional Land Transport Plan is not consistent with the GPS because it doesn't adequately provide for decarbonisation. So that's obviously before the courts, and we'll wait and see how it ultimately goes. But as an example of how these types of decisions are being scrutinised increasingly by various community groups and NGOs, and there's certainly scope for that to flow through into litigation of various kinds, particularly judicial review. Likewise, the Climate Change Response Act itself, which is of course the act that the Zero Carbon Act amended, so it incorporates the Zero Carbon Act, also is relevant to public decision makers, including local bodies. So the purpose of the Climate Change Response Act, as amended by the Zero Carbon Act, makes it clear that it's to provide a framework for policies to contribute to the global effort under the Paris Agreement to limit the global average temperature increase to 1.5 degrees. And of course, limiting the global temperature increase to 1.5 degrees really requires pretty decisive action, basically immediately, to cut emissions. So I think the IPCC in its 2018 report on global warming of 1.5 degrees said that CO2 emissions really need to drop by around 45 to 50% by 2030 from 2010 levels to have a 50 to 60% chance of keeping global warming to 1.5 degrees. So achieving net zero by 2050 won't be enough to keep global warming to 1.5 degrees. We really need to cut those emissions by 2030 quite significantly to stay on the right pathway for that. And so the relevance of the Climate Change Response Act is that, first of all, it sets out very clearly the legislative purpose of meeting the Paris Agreement obligations. It sets out specific 2050 targets and a 2030 target for methane, but not for CO2. And sets out a process including the setting of 5-year budgets for emissions and an emissions reduction plan, which the government is consulting on at the moment, of course. That is all sort of currently sort of flowing through. But when it comes to local bodies, Section 5ZN permits all public decision makers, of course, including councils and so on, to take into account the 2050 target and the emissions budget in performing a public function, power, or duty. So in essence, whatever specific statute a decision is being made under, the Climate Change Response Act authorises regard to be had to those specific considerations, in addition to any considerations that might also need to be taken into account. Now, Lawyers for Climate Action takes the view that it's also arguable that it's not only permissible, but there might be some cases where those targets and budgets are so clearly material to a decision that effectively they are mandatory considerations for a reasonable decision maker taking that decision. And an example might be, for example, if you are looking at an investment, a very significant infrastructure investment or capital investment that's expected to have a life out beyond 2050, but is also expected to have sort of high carbon emission outputs through past 2050, then you might say it would not be reasonable to enter into that decision without at least taking account of the fact that there is a statute target of net zero emissions by 2050 that might conflict with. So there's lots to think about there, and it's very nuanced, and I'm not, there's no kind of there's no simple framework for a decision. It will just depend on the particular decision and the particular framework it's being made under. But these are the sorts of things that at least decision makers should be, and advisors should be turning their minds to when they're making these sorts of decisions. Is this a situation where we should be thinking about the emissions budgets or the 2050 target? So that's the Climate Change Response Act. And just as a bit of an example, I suppose, of how the courts are treating these issues. So we've seen already in New Zealand in a number of judicial reviews over the years that the court is willing to grapple with climate change as an issue. So a few years ago now, Sarah Thompson brought a claim against the Minister for Climate Change, essentially seeking judicial review because he'd failed to update New Zealand's nationally determined contribution under the Paris Agreement following a new IPCC report. And the court was quite happy to entertain that claim, even though there was an argument that really the New Zealand's nationally determined contribution under the Paris Agreement was a policy decision for the government and not something the judge should interfere with. But the court said, well, just because it's about climate change, that doesn't mean we can't look at it. And it may have policy aspects, but it still needs to comply. The minister still needs to meet his legal obligations under the Climate Change Response Act. So certainly there's no kind of no-go area for the court here. And a more recent case is the Hauraki Coromandel Climate Action and the Thames Coromandel District Council. And in that case, Hauraki Coromandel Climate Action applied for judicial review of the council's decision not to sign the local government leaders' climate change declaration. So some of you may be aware that's a declaration that's been around for a couple of years, and I think a high proportion of councils around the country have signed it, and it's essentially intended to be a non-binding declaration and commitment to various forms of climate action. So there was a judicial review of the council's decision not to sign it. And the High Court really endorsed the view that decisions about climate change should be, are suitable to be scrutinised by the court, and really compared them to fundamental human rights type issues where there should be a high level of scrutiny and a high level of accountability. Now, the court didn't uphold the claim that the decision by the council not to sign the declaration was unreasonable, because of course establishing unreasonableness under judicial review is very difficult. The threshold is very high. To be unreasonable in a judicial review sense, a decision needs to be something no reasonable decision maker in that position could possibly have decided on. So it's more than just not the best decision. It has to be a really crazy decision. So the court said there's a logic to the council's decision, so it wasn't unreasonable. But the court did say that the decision-making process itself was unlawful because the council had failed to undertake the analysis and consultation required by the Local Government Act. And of course, there are very onerous requirements on councils in terms of public consultation if the Act requires a consultative procedure. So on that basis, the court declared the decision unlawful and directed the council to reconsider and to carry out the necessary consultation process. So I just included that as an example of the kind of area where local groups are actively calling councils to account and applying a very high level of scrutiny to their decisions around climate change. So just talking then about some of the steps that local authority decision makers might want to take. And I think, you know, a lot of these really are obvious, but it's kind of useful to remind ourselves of these things to minimize the risk of getting it wrong. So the first and obvious thing is really, it's important to understand what the climate risks are for the region you're dealing with and disclose and mitigate those risks. Sorry, I've lost control of my slides again. Hang on a sec. Okay. I don't know how to get it back to slide from current slide. Here we go. Okay, sorry about that. And look, that's, you know, there's going to be different risks in each area. Obviously, some of them will be more obvious than others. There's a huge amount of work, and I'm sure all local authorities are sort of very actively involved in this. So the next aspect, which again, I'm sure everybody is more than familiar with, is it's really important to understand the statutory basis for each decision that is being made and what that requires in terms of both process and substance. And of course, the Thames Coromandel decision is an example of where they got caught out by the process by not doing the required consultation. And I think the other thing to be aware of is that there may be more than one statute that has relevance to a decision. So the immediate decision may appear to be governed by a particular statute, but think about the wider obligations that might also apply under the Local Government Act, for example. Think about the Climate Change Response Act and whether that might have any application. Obviously, think about the climate change risks and impacts of decisions, and some of those might be decisions which have nothing to do with climate on the face of it, but when you think about it, are likely to have climate risks to them. And that might include things like location of facilities, things that make assumptions about what people will be wanting to do in the future that may not be right, given our changing climate. As I've said, I think it is useful to think about whether decisions are consistent with the Climate Change Response Act and the 2050 target and emissions budget, government emissions budgets, which we will have the first of being formally adopted in May next year. And obviously, it's important as well to think about making decisions that are consistent. So one particular, I was speaking at an Auckland Climate Festival event last week, and I think one of the issues that we've had in Auckland is a degree of disconnect between some policy statements that the council has made and then what the council and its council-controlled organisations have actually done. So I think it's very important from a leadership point of view and accountability point of view that where councils have declared climate emergencies and have adopted these policy statements that commit themselves to taking climate action, that they actually follow through with them. And I think increasingly we will see scrutiny where that doesn't occur. Right, so that was really all I had to say about councils. And then to finish off, we just thought it would be good to talk a little bit about, you know, what tools are there for you as an individual or an organisation. If you are looking at climate action, there's various ways the law can help you to kick that off. And so some of the things which are useful to flag are the Official Information Act and the Local Government Information and Meetings Act. So under the Official Information Act, anybody can require information to be disclosed by a whole range of public bodies, ministers, government departments, public agencies. And generally all that it requires is a written request. There's no particular form you need to use. It's useful to say explicitly that in the request that it's an Official Information Act request, just in case they don't pick that up themselves. But even if you don't say that, then a body that's subject to the Act should still treat it as an Official Information Act request. And so they are then required to provide the information subject to, there are a number of exceptions for things like where the cost of doing so would be unreasonable and disproportionate, or there's specific confidentiality issues or privacy issues or legal issues. But really the exceptions are quite narrow. So the basic premise of the Official Information Act is that official information should be made available. So if you want to know what a particular government department or a public body is doing about a particular aspect of climate action, you know, what are they doing about reducing their carbon emissions? Are they measuring their carbon emissions? Have they looked at the risks associated with a particular project? You can write and ask them, and they should tell you. And I think just even asking the questions is often a very powerful process, because the officials working in that area may simply not have thought about these issues. And so when the question gets raised, sometimes that might prompt them to go back and do another bit of analysis, and it might improve the decisions that are being made. So you might be doing everybody a favor by flagging some of these things. And so that's the Official Information Act applies to central government and a whole lot of public agencies. There's essentially the same obligations on local government under the Local Government Information and Meetings Act. So you can do exactly the same thing under that act. And of course, there's a lot of public consultation and ability to attend public meetings at local government level. So it's well worth looking into that. And often you can watch meetings online if you can't be there in person, and obtain documents for the meetings online. So there's an enormous body of information and an enormous ability to get really involved in local government decision making and really find out what's going on. And that's very helpful if you are keen to campaign and influence outcomes. Now, for private, well, not private, sorry, for public companies, there are it's possible to make shareholder information requests under the Companies Act. And again, there's quite a wide range of information that companies need to provide if you make those requests. So again, a really useful idea if you're a shareholder of a company and you want to know what they're doing about climate change. Are they measuring their emissions? What plans do they have? What risks have they identified? Write to them and ask them, and just make clear you're a shareholder and you're making the request as a shareholder under the Companies Act, and see what they say. And again, you might really be doing them a favor because they may simply have not thought about these issues, and it probably would be very helpful if they do. And actually, I didn't talk about earlier, but one of the areas where there's been a lot of climate related litigation in Australia is essentially shareholders calling on companies or investment funds, so retirement funds, calling on them to disclose their climate risk policies, and having a lot of success with that. So other tools, obviously, I've already talked about the rights to attend and speak at public meetings. That's a great way to get your message across. Participate in consultation processes. I think a lot of us are suffering a little bit from consultation fatigue at the moment because we've had such a deluge of new legislation and new regulation and the Climate Change Commission's advice and so on and so forth. It's pretty hard to keep up with. So, you know, the more people who are willing to get involved, the better. Pick one and get involved and make a submission. It's a great way to get involved. And then another way, which is, you know, old-fashioned, but I think also can be really powerful, is just writing letters. writing letters to your ministers, to particular ministers, your local MPs, your local councillors. The feedback I have from people in those positions is that they really pay attention, particularly to individual messages. I think they get a bit used to receiving the mass mail outs that a lot of NGOs encourage people to send, and a personalised individual letter really does get their attention, and most of them will take the time to reply. So that is well worth using. There's obviously using the media and social media. So we're kind of lucky in this country. It's really quite easy to get things published. So if you've got something to say, you think that you'd like to share, put it out there, and then join a group. We've got lots of fantastic NGOs in this country, all around the place, local groups, national groups. So get involved. There's plenty to do. And then, just to make sure that we've finished up with a bit of a legal moment, there's always complaining. It's probably, shouldn't be your go-to, but it can be very effective. And sometimes it's important to complain. And so I mentioned earlier that Lawyers for Climate Action had made a complaint about first gas to the Advertising Standards Authority, which was upheld. So anybody can do that. You don't need to be a lawyer to do that. Equally, the Commerce Commission, of course, has jurisdiction over the Fair Trading Act. So if you see advertising or claims being made that you think are misleading, then raise it. Go to the company, and if you're not satisfied, go to the Advertising Standards Authority or the Commerce Commission. Equally, and I'm afraid I'm guilty of this, I do send letters to the editor about misleading media articles, and with some success. Actually, I have to say, often I get a very reasonable reply. And I think the more people that write to the editors of newspapers and so on, saying, look, I don't think that article was correct about climate change, and I think there's a risk it was misleading, and I think you need to be more careful, they'll take that seriously and take it into account, and we'll get higher standards, hopefully. And then if that doesn't work, again, anyone can make a complaint to the Media Council if they feel that the reporting it fails to comply with the Media Council's code. And similarly, if local bodies or government bodies aren't complying with their information disclosure obligations, you can complain to the Ombudsman. So there's lots of steps you can take. So encourage you all to get out there and go for it. Now, we don't seem to have had any questions. So here's your last opportunity now in the last 5 minutes to fire them through if you do have any. Otherwise, I just encourage you to, get involved, and I hope you found this useful. Deborah, any last thoughts from you?
Oh, I'm surprised there are no questions. I expected there to be some questions, but maybe people will think about them afterwards, and if they have questions, then they can ask. Yeah. Mm-hmm. Yeah, that's right. Yeah, so do check out our website for Lawyers for Climate Action, and feel free to get in touch. If you are a lawyer, then please do join us, and if you're not, you're welcome to become an associate. Oh, we do have a question. Yes. What sort of time frame do we see for increased legislative requirement for businesses to disclose greenhouse gas emissions? So the time frame, so the Act has just been passed. I'm sorry, I haven't checked exactly what the time frame under the legislation is, but I'm not sure there's a fixed implementation date at the moment, because we're waiting for the XRB to prepare the detailed disclosure requirements. But I think it's envisaged that the reporting requirements will start to kick in from financial years starting in 2022 through to 2023. And I think it will be a progressive implementation. So there'll be a kind of a first phase implementation where there's sort of a, not so comprehensive disclosure requirements, but more of a putting
frameworks in place stage, and the requirements will gradually ramp up over the next couple of years. But as I said, that will only initially be for, and I apologise because due to my technical incompetence, I'm not able to have other screens open in front of me, so I haven't got this in front of me. But essentially, those requirements will apply initially to the banks, insurers, major issuers. So that's issuers above a certain size, and I can't immediately say what it is, but it's really the big corporates. For smaller businesses and certainly for unlisted businesses, there's no mandatory framework envisaged at the moment. It's more the fact that that may come in eventually, although it's not on the legislative agenda. But if you look at the way things are going, I think it's increasingly likely that the scope of that legislation will be broadened out over time, but it's probably going to be a 5 to 10 year time frame rather than immediate. And I also think, as I was describing, the flow through effects of the banks and the insurance companies needing to make that disclosure will be that they will make their customers provide them with quite comprehensive information. So although there won't be a direct disclosure obligation, businesses will increasingly find themselves over the next, I would guess, sort of 2 to 5 years needing to have that information available for their investors and their lenders. So hopefully that made some sense. And then another question, is there an avenue to require a priority order be given between different pieces of legislation such that local government can give effect to Section 5ZN when considering applications for new development made under the RMA? So my understanding of that, and Deborah, jump in if you have a different view on this, is that the effect of Section 5ZN is it means that council can take it into account when it's making a decision under the RMA, irrespective of what the RMA may say. In terms of the relative weight to be given, that's not clear. So I think I'm sort of guessing that, well, look, I don't know actually. I think it would depend on the specific decision and exactly what the statutory provisions said, what weight should be given to Section 5ZN relative to other considerations. But certainly it's clear that 5ZN permits the 2050 target to be part of that decision-making matrix. And I think you'd need to analyse a specific situation to form a view on what weight it should be given. But it's a good question. I don't immediately know the answer to. Any thoughts on that, Deborah?
No, I can't contribute at all. Sorry.
I think it's the kind of thing that there's probably no real answer to, and we'll find out when someone gets it wrong and it gets taken to court. Sorry, I can't be more helpful on that. Anyway, well, that thank you for those questions. That does bring us to the end of our time. So thank you very much from me for listening and bearing with us. We are sorry we couldn't be there in person, but thank you for joining.
Yes.
Thanks very much.